This corrupt police officer violated an auditor's First Amendment rights, but soon got some karma when he was sued. Watch how he was owned in the courtroom and taken to the cleaners by the attorney.
Not being disorderly.
Okay. I'm not going to tell you again. Get up.
I have not committed a crime. I can't get up. You're hurting me.
Were you offended by the contents of his signs?
No,
Why did you think they were offensive?
I didn't think they were offensive.
So why did you arrest them? But specifically the First Amendment, you don't remember.
Correct.
Starting off with this sergeant who was served with some quick karma after he did the unthinkable. In December 2018, veteran First Amendment auditor and activist Wesley Knowles, known for his YouTube channel Otto the Watchdog, was standing on a curb with various placards, peacefully exercising his right to free speech. That is when Sergeant Nick Dial and a few other officers approached, attempting to bully and intimidate him.
How are you?
Well, I was doing just fine until just a minute ago.
I've already heard you say a cuss word once, so...
What do your other signs say, sir? Sir, what do your other signs say?
What am I doing?
Okay, can I see your other signs?
No, leave my feet away.
Sir, we've gotten a complaint of you out here holding up profanities.
Okay.
Okay, if you don't let me look at your sign, I'll take you in custody for disorderly conduct.
Not being disorderly.
Okay. I'm not going to tell you again. All right?
I don't consent to any searches or seizures.
Okay. This is offensive to people that are driving by and families that are driving by.
Yes.
Yes, it's disorderly conduct.
What's the penal code?
It's disorderly conduct.
Can you read that to me?
It's disorderly conduct.
Sergeant kicked the placards from Otto's hands and in mere seconds planned to arrest him. The auditor, realizing how devastating the situation is getting, decided to get on the ground to passively resist the cop.
Roll over. Since he's failing the ID, take him to jail for disorderly conduct.
When we're here answering a complaint and you refuse to identify yourself, that is a crime. When you're displaying these signs and people are calling because it's offensive to them, that is another crime. So yes, you have committed a crime. You've committed two.
You didn't warn me.
We don't have to warn you. Ignorance of the law.
I asked you politely to see your signs and you said
I
no.
don't consent to any searches or seizures of my property or my person.
I'm not going to take you.
If this illegal arrest wasn't enough, the officers continued to torment the poor auditor as they left his camera on the road.
I would like to see your supervisor right now before you assault me any further. I am being assaulted. I have not committed a crime. I have not committed a crime.
Get up.
I have not committed a crime. I can't get up. You're hurting me. You are hurting me.
Then get up.
I cannot get
Then
up
get
like
up.
this. I can't
Get
get
up.
up like this.
They lift you up.
I'm trying to get up. Matt, please
Get up.
help me to my knees.
We already have one.
Well, help me
All over
again.
everyone. Now they'll lift you straight
Up on your
up.
feet.
Stand up.
Okay, help me up. I have committed no crime. I have committed no crime whatsoever.
Soon after his arrest, Otto was charged with disorderly conduct, obscene language, and resisting arrest. Ultimately, the charges were dropped due to inconclusive evidence, and Otto filed a civil rights lawsuit against Sergeant Dial and the Royce City. The sergeant was then brought to a deposition where Otto's attorney wiped the floor with him.
As I explained earlier, one, it was an officer safety issue because I don't know what the signs are made out of or what they were. And they could be used as a weapon. And secondly, we were still investigating whether a crime had been committed. And he was unwilling to show us what the other two signs or what the sign said other than what we could see.
Did you believe that Mr. Knowles had an obligation to give you those signs?
What do you mean, an obligation?
Did you have the right to see those signs?
Well, it's part of our investigation.
Did Mr. Knowles have the right to refuse showing you the signs?
Anybody can refuse anything.
Objection form.
Why did you hit the sign so hard?
With 11 years of experience in the police department, you would expect Sergeant Dial to appear a bit more confident and have ample knowledge of the law. However, contrary to this, he proved how inadequate he is in basic constitutional law.
I don't know what your definition of hard and soft is, and that was 5 years ago.
How do you define hard and soft? You can use your own definition, please.
In regards to what?
The level of force that you apply to the signs.
I mean, I don't know how I would describe hitting a sign soft or hard.
Why didn't you use less force when touching the signs?
I didn't know I used too much force.
Could you have used less force when touching the signs?
Objection, in regards to what? I mean, what was the amount of force that I used?
You said earlier that you conducted an investigation after you arrived on the scene that day with Knowles. What were the results of that investigation?
In regards to what?
Did you find anything during your investigation that caused you to arrest Knowles, that caused anyone to arrest Knowles?
Through our investigation, we determined that disorderly conduct had been committed.
How did disorderly conduct get committed?
Due to the verbiage that was on the signs, and we had received complaints.
The sergeant had violated Otto's First, Fourth, and 14th Amendment rights, and it turns out he also has no clue about disorderly conduct.
If you received the same complaints and those signs had said something different, would Knowles have been arrested?
The same complaints in what? Because the complaint we had was, it was vulgar and offensive.
What I'm asking you is, if the complaints were the same, but the contents of the signs were different, would Knowles have been arrested?
Objection, Swan.
What if the sign said Blue Lives Matter?
How is Blue Lives? There's nothing vulgar about Blue Lives Matter. There's no profanity in Blue Lives Matter.
Are you saying that if the sign said Blue Lives Matter, Knowles would not have been arrested?
I'm telling you that based on the complaints that we received that day, a guy telling me that he was offended by the profanity and vulgar that was being used in the signs.
Objection, non-responsive.
Dial refused to cite any law that had been broken that day and claimed to have made the arrest just because someone was hurt with what the placard had on them. It appears he really needs to read a book or two on the Constitution.
The complaints were the same, but the sign said Blue Lives Matter. Would Knowles have been arrested that day?
Objection, fam. There's no vulgar or profanity in in the verb or term, the verbiage or term Blue Lives Matter.
Do you think anyone that says a bad word publicly should be arrested?
No.
Why not?
Did someone complain on them, or they just out there just throwing a fit? No complaints. I mean, there's several reasons why we would not arrest someone. I mean, if nobody finds it offensive, then disorderly conduct's not met.
So if the language on the signs had not offended someone, Knowles would have been arrested, or would he not have been arrested?
So you're telling me we didn't receive any calls and nobody complained to us? Would we have arrested Knowles that day?
Correct.
No, we wouldn't not have.
The attorney was doing a fascinating job holding the sergeant accountable, but the best part of the deposition was yet to come.
What specifically did Clark say to you about Knowles' prior disorderly conduct?
He was explaining it to Knowles that as I'm walking up, he's explaining it to him that, look, I've already heard you out here cussing at people.
So he was talking to Knowles, not you.
That is correct.
Did any motorists complain about the prior alleged profanities that Knowles said before you arrived?
Well, the one gentleman told me about the signs and regarding what the people on 911 called in about, I do not recall that.
If anyone complained about verbal language and you didn't hear any allegedly profane verbal language from Knowles at the scene?
I did not hear it, but I heard Clark explaining to Knowles that he has already witnessed it or observed it himself.
Do you know one word of profanity that Knowles said?
No, I do not.
And you are not aware of any person that was offended by what Knowles said?
As the sergeant himself claimed that the arrest was made due to the contents of the placard, the attorney was ready with some even better questions regarding that which would silence the corrupt cop.
Were you offended by the contents of his signs?
No,
Why did you think they were offensive?
I didn't think they were offensive.
So why did you arrest them?
He was arrested. He was arrested because people had either called 911 or flagged us down about a gentleman that had offensive signs, and obviously Clark observed him using offensive language while he was there.
If Knowles said fuck the draft, would you have arrested him?
Objection. Directly to me or to who?
To anyone.
If they were offended about it, yes.
So are you saying that if anyone said anything offensive to anyone, you would arrest them?
I mean, I don't think certain terms, just because you're offended by them, does not constitute that. But when you have vulgarities or profanities in there,
The sergeant kept stumbling, making blunder after blunder, and the attorney was closing in on the core issue, First Amendment right. Clearly, this would be the final blow, completely dismantling the sergeant's shaky defense.
So you would arrest somebody if a citizen complained about vulgarities?
Objection.
so a citizen made the police department or dispatch aware that they had used profanities and vulgarities and were,
Have you arrested more than 5 people in your career?
I believe that would be an accurate statement.
Have you observed more than 10 arrests in your career?
I'd probably say I have observed more than 10 arrests in my career.
Have you observed more than 25?
That I don't know.
Have you observed more than 30 arrests in your career?
I don't know.
Do you remember any specific details about your training regarding First Amendment rights?
No, I do not.
Are you saying that you don't remember one word from your training regarding First Amendment rights?
Objection.
That is correct.
It is shocking that a 10-year police veteran didn't have any clue about the First Amendment. This poses a huge question to the entire law enforcement community. What kind of officers are being produced?
We went over the elements of the Constitution, and I believe the First Amendment is part of the Constitution.
But specifically the First Amendment, you don't remember.
Correct.
Do you remember how long you spent studying constitutional rights?
No, I do not.
Have you had any training related to constitutional rights since you became an officer?
I do not recall.
What topics have you been trained on since you became an officer?
I don't recall all of them.
Name one.
Accident investigation.
Anything else?
Well, I'm sure there's others.
Where did you receive the training regarding constitutional rights in 2007?
But as when I was in the police academy, is that what you're referring to?
I'm referring to the training that you refer to, that you received in 2007 regarding First Amendment rights.
The Collin County, Collin County, Collin College Police Academy.
And who trained you in constitutional rights?
Could not tell you.
Because you don't remember?
You're asking for the instructor's name? No, I do not remember the instructor's name.
The lack of IQ in this officer is clearly shocking for someone holding such a high position.
Do you remember anything about the protections provided to citizens by the First Amendment?
No, I do not.
Are you aware that the First Amendment gives citizens what's known as the freedom of speech? Have you heard of the freedom of speech?
have.
What do you think that means?
Interpretations are a dime a dozen, but basically someone can speak freely.
Does the First Amendment protect a person from being arrested because of what they say?
Objection form calls for legal conclusion.
Do I answer it?
Answer.
I think at times it may.
Has the police department provided you with any subsequent training on constitutional rights since you've been an active officer?
I do not recall.
Have you received any training, guidance, or instruction regarding First Amendment rights while you've been a police officer?
Objection form.
In the police academy, I know we went over the constitutional rights.
But anything since then?
I do not recall.
Well, this is what happens when you haven't been given any class or training on the First Amendment and the Constitution. Soon after this deposition, the city decided to grant Otto close to $25,000 to settle the lawsuit. Despite the sergeant's lack of knowledge, he was subjected to no disciplinary action, but was instead promoted to lieutenant. Well, the actions of this next cop will make Sergeant Dial seem like an angel in comparison.
Today is that day. You are not the law. You don't interpret the law. You don't enforce the law. You're not above the law.
In 2023, a former Clark County sheriff who oversaw the police and fire department was accused of stealing over $5 million from taxpayers' money and using that money to build a mansion, buy a Cessna airplane, and luxury car. As a result, he was charged with 25 felonies, and that's when the court proceeding started with Judge Larry Medlock.
Count 2, theft as a level 5 felony. It would indicate that pursuant to Indiana Code 35-44.1, you then personally sold said Hellcat for $83,000, $83,716. Count 4, theft is a level 6 felony under Indiana Code 35-43-4-2A. First 3 counts are level 5 felonies, which have a range of imprisonment from 1 year to 6 years, with the advisory sentence being 3 years and up to a $10,000 fine. Counts 4 through 15 are all level 6 felonies, which have a range of imprisonment of no time in jail if treated as a misdemeanor to 2.5 years at the Indiana Department of Corrections, with the advisory sentence being 1 year and up to a $10,000 fine.
Jamie sat through the initial court proceedings as the judge read aloud the charges against him. The sheriff displayed no remorse throughout it all, maintaining a cold, expressionless demeanor.
And then you will surrender it to the court by 4 p.m. next Monday, because it's my understanding the court here is closed tomorrow.
Yes, sir.
He will surrender all firearms except one shotgun of his choice to Indiana State Police. Being from the country, or as Mr. Wilder said, Washington County, I keep my shotgun with double aught near me, along with a 45, but I think one shotgun for personal protection is appropriate for him to maintain. Will not leave the state of Indiana without permission of the court, and they'll post $75,000 in cash. Mr. Knoll, Mr. Wilder, I know you wanted him released without posting any bond, but it's a unique case, and if you don't like my decision, I'm happy for you to appeal it. It won't be the first time you've appealed me, and the Court of Appeals told you I was right, so I'm happy for you to accept that challenge if you're so pleased. I'm not going to have you report in.
Judge Medlock was fairly calm about the case, but made one thing very clear. Jamie would have no weapon except one shotgun.
You keep one shotgun only. Try to deceive me, you will not like the consequences.
Yes,
understand?
Yes, Your Honor.
Okay.
And then, Judge, the issue of return of all other items, see if we can just take up in another hearing
Well, it wasn't set for today, so
No,
yeah, we'll deal with that at another time. I assume now that everything's going to be unsealed, there'll be a lot of new things brought before the court that
yes, sir.
we'll address in due time.
Thank you, Judge.
Anything else?
No, Your Honor. Nothing else from us, Judge. Thank you.
All right, we'll be off record. Thank you all.
The corrupt sergeant had a habit of breaking the law, and he once again ignored the judge's command and was found to have multiple weapons in his home during a police raid. His bail was annulled, and he was quickly called to court again.
I told Mr. Knoll, don't do anything stupid. Do not try to deceive me, defy me. You will not like the consequences. Today is that day. You are not the law. You don't interpret the law. You don't enforce the law. You're not above the law. I find that you are in contempt of this court. Take him into custody. No, that's enough. I'll find you guys in contempt for disrupting the proceedings, and you'll be there right there with him.
The judge didn't spare him this time and made sure to teach him a lesson by taunting him about his appearance in a TV show once named 60 Days In.
Now, what is an appropriate sanction? The question is, I can sentence him up to 180 days without a trial, or I can sentence him to a day, or I can release him. You know what I think the answer is? 60 days in. That's what I think the answer is today. Now, Mr. Wilder.
Yes, Your Honor.
Or Mr. Boyles, I apologize, Mr. Boyles, you're lead. Before he is released, I'll take your suggestion. I want an independent individual to scour that household to determine that there's no further weapons. I find that Mr. Hurdle's original argument that he was trying to make that I sustained, an officer of the law, every time I go into court, I hear, I didn't know it was there. I didn't know it was there. I really didn't. You've heard that a million times. You've heard it a million times, and yet you still take them into custody, would be my guess. Every officer in the world has heard, I didn't know it was there. It's my friends. I'm not buying it. It's your burden. It's your responsibility. And today, the court will enforce that. Take it.
He was sentenced to 60 days in prison and was charged with 31 felonies. In August 2024, Knoll shamelessly pleaded guilty to 27 of the 31 felony charges against him.
It is. Defendant's Exhibit A?
Yes, Your Honor.
That's acceptable. Cross-examination, Mr. Hurdle.
Mr. Tidman, I guess maybe I don't fully understand, or maybe in Ripley County we use the IRS for something different each and every time, no matter what's been charged.
No, sir.
Okay, because that's what I got.
Judge, could he answer? He wasn't finished. He asked a question. Can he answer?
Is that an objection?
It is an objection. He cut the witness off and he wasn't finished answering.
Response, Mr. Hurdle?
I'll withdraw the question.
Thank you.
You may.
So all due respect, I'll repeat the question, Mr. Tidman. Is it your testimony today that if someone scores a 0 on the IRAS, the court should just release them on their own recognizance?
No, sir. That decision is up to the judge. I can only simply make an IRAS recommendation and a supervision level recommendation.
Okay. And so you're not saying bond should be 1,000, 5,000, 10,000. You're talking about once bond potentially.
This wasn't the last time a corrupt cop was taken to the cleaners inside the court. Cops are often protected by qualified immunity after breaking the law. However, today we bring you cases of crooked and corrupt police officers who made some huge mistakes and were instantly owned in the courtroom. In December of 2012, suspect Anthony Waller was brought in front of a judge after he was sentenced on assault charges. As he tried to speak to the judge, the officer holding him did something terrible, taking the law into his own hands.
Investigation for false imprisonment, assault in the third degree, assault as a class 2 felony, and a misdemeanor charge as well in possession of drug paraphernalia.
I'd like to object first. If I'm under investigation, I thought the investigation came first, then the rest came.
Get on your feet. Don't turn on me. Get on your feet.
Deputy Brady Lovingair assaulted the poor man and pushed him onto the ground before taking him to jail. However, his actions were found unlawful and he was suspended from his job. He eventually resigned from the position. Meanwhile, Waller was awarded $50,000 in compensation by a federal jury. Now, while this cop made a mistake in court, this next tyrant officer was punished for something more sinister.
The court commits you to the custody of the Commissioner of Corrections for a period of 270 months. That's 270.
In May of 2020, Officer Derek Chauvin knelt on the neck of poor George Floyd, eventually causing his death. This led to massive protests all over the world and also the start of the BLM movement. Officer Chauvin was then charged and eventually found guilty of third-degree murder and second-degree manslaughter.
I wanted to thank everybody for being here and for providing the input you did. Not just the people who were in the courtroom here, but also those who provided written statements, both from the Floyd family and the defendant's family. I've read all the impact statements that were submitted earlier and listened carefully to all the input here today. And it is truly appreciated that you took the time to stay with this case and to provide me with input. I have reviewed the pre-sentence investigation and carefully considered all the facts of the case and the law, but my comments are actually going to be very brief. Most of it's going to be in writing. I have a 22-page memorandum that is going to be attached to the sentencing order. And why am I doing it in writing? To emphasize the fact that determining the appropriate sentence in any case, and in this case, is a legal analysis. It's applying the rule of law to the facts of an individual and specific case. And that is why, as opposed to trying to being profound here on the record, I prefer that you read the legal analysis that explains how I determined the sentence in this case.
Now, high-profile cases like these must be handled carefully in order to set a strong precedent for the future. The judge reminded everyone that emotions do not play any part in the sentencing.
What the case is, or what the sentence is not based on, is emotion or sympathy. But at the same time, I want to acknowledge the deep and tremendous pain that all the families are feeling, especially the Floyd family. You have our sympathies. And I acknowledge and hear the pain that you are feeling. I acknowledge the pain not only of those in this courtroom, but the Floyd family who are outside this courtroom and other members of the community. It has been painful throughout Hennepin County, throughout the state of Minnesota, and even the country. But most importantly, we need to recognize the pain of the Floyd family.
Derek stood there listening, without a trace of shame on his face. It was clear he felt no remorse for his action.
I'm going to attempt to be profound or clever, because it's not the appropriate time. I'm not basing my sentence also on public opinion. I am not basing it on any attempt to send any messages. A trial court judge, the job of a trial court judge is to apply the law to specific facts and to deal with individual cases.
Finally, after a short speech, the judge handed over the much-awaited sentence, which brought some sort of peace to Floyd's family and the people that were hurting all over the country.
Mr. Chauvin, as to count 1, based on the verdict of the jury finding you guilty of unintentional second-degree murder while committing a felony under Minnesota Statute 609.19 subdivision 2 paren 1, it is the judgment of the court that you now stand convicted of that offense. Pursuant to Minnesota Statute section 609.04, counts 2 and 3 will remain unadjudicated as they are lesser offenses of count 1. As sentenced for count 1, the court commits you to the custody of the Commissioner of Corrections for a period of 270 months. That's 270. That is a 10-year addition to the presumptive sentence of 150 months. This is based on your abuse of a position of trust and authority, and also the particular cruelty shown to George Floyd.
Chauvin was also required to register as a predatory offender as his life came crashing down after being sentenced to 22.5 years in prison.
You are granted credit for 199 days already served. Pay the mandatory surcharge of $78 to be paid from prison wages. You're prohibited from possessing firearms, ammunition, or explosives for the remainder of your life. Provide a DNA sample as required by law. Register as a predatory offender as required by law. And you will receive a copy of the order and also the attached memorandum explaining the court's analysis. Anything further from the state?
If this needs to be said, we just ask that it be executed forthwith.
Defendant is remanded to the custody of the sheriff to be transported back to the DOC or whichever custody is currently holding him. Anything from the defense?
No, Your Honor.
All right. Thank you. We are adjourned.
Chauvin was sent to Oak Parks Heights Prison, and in 2024, he was stabbed 22 times by another inmate. However, he is expected to make a full recovery. While Derek was punished, here is another corrupt cop who did the unthinkable and was punished in court.
In the unclassified felony of armed criminal action, I sentence you to a term of incarceration of 6 years in the Missouri Department of Corrections.
In December of 2019, 26-year-old Cameron Lamb was sitting in his car inside his garage when Officer Eric DeVolcanair and murdered him.
Cameron Lamb is dead. And Eric DeVolcanair, that's undisputed. Cameron Lamb was by all accounts a helpful and loving son, brother, father, and friend. People who have contacted me and who I have heard from today have described him as funny, caring, giving. Miss Gray called him a protector, a jokester, and my favorite of all the ones that I read, not a saint, but our angel.
Cameron Lamb was trying to chase his girlfriend, but halfway he changed his mind and he headed back home. The officers should have de-escalated the situation, but these tyrants were only focused on ending his life.
Also, as I'm weighing all these facts, it can't be overlooked that the events of December 3rd of 2019 were initially set into motion by Cameron Lamb and his decision to chase his girlfriend through city streets at dangerously high speeds, putting motorists and other members of the public at risk. However, those events tragically concluded with the actions of Troy Schwam and the defendant pulling up to defendant's house, Sergeant Schwam pulling into the driveway, immediately getting out with his weapon drawn, rapidly moving, without taking a breath, without pausing for the briefest of moments to consider where they were going, what they would find when they got back there, whether they were acting lawfully in doing so. That is made even more aggravating as the court considers an appropriate sentence, in this case by the fact that the one person who ultimately did take a breath that morning was Cameron Lamb.
DeVolcanair was in civil clothes and had entered his property without notifying him. It only then took him 9 more seconds to fire his gun and kill Lamb on the spot.
He did this when at some point, while he was chasing his girlfriend, he decided to discontinue the chase and to go home. Cameron Lamb is not racing through the streets of his neighborhood at this point. He's not driving through yards to get away from anyone. He does not abandon the truck and let it roll into someone's yard while he flees on foot. Rather, he simply pulls into the driveway of his home, pulls around back, puts the vehicle into reverse, and slowly begins backing it down the driveway, under the carport, and into his garage.
The officer had no remorse on his face, and to make matters worse, the judge even tried to side with him, claiming that he did not intend to murder him.
And it is hard to accept this distinction. I know that. Murder and involuntary manslaughter arising from criminal negligence are two different things. They are different legal concepts. They are different things. Eric DeValconaire is not Derek Chauvin, who murdered George Floyd. Eric DeValconaire is not one of the 3 men in Georgia convicted of running down and Ahmaud Arbery. This is a mitigating factor. Defendant has no prior criminal history. His ORAS scores him as a low risk in all categories. Defendant's history as a police officer, husband and father, friend and colleague is also a mitigating factor that I have taken into account, as his father asked me to do, which I was already going to do, and that is to consider the totality of the circumstances and to consider the totality of the defendant's life.
Judge Dale Youngs appeared to extend some level of courtesy to the police officer, with the Kansas City Police Department also backing their officer.
The facts and the circumstances in the history of defendant's career and his life that have been presented to this court have demonstrated he has not hesitated to immediately take action when he believed the circumstances surrounding him warranted it. And this trait has generally served him and others well. It also failed him, as it did on December 3rd of 2019.
Finally, the judge announced the sentence, and sadly, it was nothing more than a slap on the wrist.
Cameron Lamb is dead. Eric DeValconaire, and the court has found that that happened because the defendant acted without considering or being aware of the substantial and unjustifiable risks associated with his conduct, and that his actions were a gross deviation from the standard of care that a reasonable person would exercise in the situation. DeValconaire, on count 1, the Class E felony of involuntary manslaughter in the 2nd degree, I sentence you to a term of incarceration in the Missouri Division of Adult Institutions of 3 years. On the unclassified felony of armed criminal action, I sentence you to a term of incarceration of 6 years in the Missouri Department of Corrections. Those cases, or rather those counts and sentences, will run concurrent with one another for a total term of incarceration of 6 years.
DeValconaire was sentenced to 6 years in prison for brutally murdering an innocent man. Shockingly, in December of 2024, the sentence was commuted, and he is expected to be out of prison soon. Now, while this officer got lucky, this next tyrant was rightfully sentenced after doing something bizarre.
Verdict reads, we the jury, having found the defendant Aaron York Dean guilty beyond a reasonable doubt of the offense of assess his punishment at confinement in the Texas Department of Criminal Justice for 11 years, 10 months, 12 days.
In 2019, Fort Worth police officer Aaron Dean was called to a residence where he fatally shot the homeowner, Atiana Jefferson, from her bedroom window. He was found guilty of manslaughter. The judge did not take long to announce his sentence.
Y'all did fabulous when we did the guilt-innocence verdict, okay? Same rules apply. I don't know what this verdict is. Can't have any emotions, all right? Let's bring him in. Verdict reads, we the jury, having found the defendant Aaron York Dean guilty beyond a reasonable doubt of the offense of manslaughter, assess his punishment at confinement in the Texas Department of Criminal Justice for 11 years, 10 months, 12 days. They do not assess a fine. And it is signed by the presiding juror. You may be seated. Thank you very much.
Miss Jefferson was carrying no weapons whatsoever and was coming to answer the door when the tyrant cop pulled the trigger.
Juror number 1, is this your verdict?
Yes, Your Honor.
Juror number 3, is this your verdict?
Yes, Your Honor.
Juror number 4, is this your verdict?
Yes, Your Honor.
Juror number 6, is this your verdict?
Yes, Your Honor.
Juror number 9, is this your verdict? Juror number 37, is this your verdict?
Yes, Your Honor.
Juror number 38, is this your verdict?
Yes, Your Honor.
Your verdict will be received and filed. Thank you very much. Mr. Gill, Mr. Brissett, is there any legal reason why sentence should not be pronounced?
No legal reason.
Mr. Dean, it's the jury having found you guilty of the offense of manslaughter and assessed this punishment. It's the order of the court you be remanded to the custody of the sheriff, be delivered to the director of the Texas Department of Criminal Justice To serve your sentence as required by law, you will receive credit for all the time that you have served in custody on this case from the date of your original arrest.
Dean was immediately kicked out of the job and now faced a prison sentence of 11 years.
If you are indigent and cannot afford a lawyer, I would conduct an indigency hearing to determine if you are indigent. And if you are indigent, I would appoint a lawyer to represent you on appeal and provide you a record of this appeal of this trial at no cost. Mr. Gill, Mr. Brissett, if y'all will remain on his case pending his decision whether he wishes to appeal, and if you'll furnish the information for the trial court certification of appeal before you leave here today, I would appreciate it. Is there an allocution? Yes. You may be seated. Thank you very much.
Moving on, this deputy committed the unthinkable, murdering his girlfriend, and was sentenced to life in prison.
The detective said, side chick, that's his baby mama. And there's a possibility that the boy is his son. I'm thinking we're supposed to be the good guys. He's supposed to be watching my back.
It is rare to see a police officer held accountable for their crime, but today we bring you some of the most shocking cases of corrupt officers who did the unthinkable and faced justice in court. Starting with a Border Patrol agent who made the most shocking decision of his life. On April 9th, 2018, Laredo police officers and Border Patrol agents were notified about a double homicide that had occurred in a park. The suspect was another Border Patrol agent, Ronald Burgos Avias, who was in his car when the officer stopped him. It wasn't until 2023 that this case was on trial, and the first responders were telling what happened.
The person that was using that car at the time was supposed to meet a Border Patrol agent at the Father Magnoble Park. Okay. The transmission that came in was the boyfriend's name was Anthony Burgos.
Okay.
When the radio transmission came up for Anthony Burgos, there was only one Border Patrol agent that was at that location with us. I had just seen him. I had never seen this person before. I see him. He's right near the car, and so I wave him over. I say, "Hey, come here." As he's walking up to us, the name says Burgos. So we look at the name. I'm looking at the name as he's coming over, and I'm just like, "Hey, what?" I think this is the person they just called over the radio, but they said Anthony, and I look at the first name and it's an R.
Ronald Burgos had just committed the ultimate blunder, and he was about to be taken to the cleaners by his fellow Border Patrol agents who wouldn't fall for his bluff.
Tells him, "Hey, what's your name, man?" And he says, "Ronald Burgos." And we're looking for Anthony Burgos. And radio transmissions are coming through, and so it's kind of getting a little hectic. Burgos approaches closer to Reyes. I'm walking next to him. I'm the only uniformed officer. So I'm right next to him, and he says, "Hey man, what's your name?" And then Burgos says, "Ronald Burgos Aviles." He only uses his last names. So then Rick's like, "What's your name, dude? Why are you not telling me your name? What's your name?" And he says, "My name's Ronald Burgos Aviles." And he says, You're not telling me your name. Do you have an ID or something?" And he's like, "No, I don't have an ID."
The Border Patrol agent had just arrived after murdering his ex-girlfriend, the mother of his child Griselda Hernandez, and his 1-year-old baby Dominic Hernandez. It was appalling to see how Burgos reacted after doing something as heinous as this.
Yes, so once I took the belt off, I put it behind his unit, and then I patted him down as the unit approached us. So I patted him down. I located a phone on him and a driver's license in his shirt pocket.
Okay, so, and what did you do with those 2 items?
I turned over the driver's license to Detective Reyes, and the cell phone, I put it with his property that I had already taken, which was his Sam Brown. I put it in the back of his truck.
The prosecutor moved forward to show the court the dash cam video of the arrest of the Border Patrol agent. As you can see, the corrupt officer had no remorse on his face.
I'm sorry, brother. 7643-513851. What is it that he's doing in that scene?
He's wiping his arms. Looks like he's cleaning something off or.
What was it that he did right before he wiped his arms?
He licked his finger.
Officer Ronald Burgos was desperately wiping his arms and even sucking his fingers, trying to remove any trace of evidence. He had just used a knife to his ex-girlfriend and their young son, with the evidence plainly visible to everyone.
Come on, man. Oh yeah, he could have just told me straight up, man, instead of making me go through all this embarrassing big ordeal.
As the trial progressed, witnesses came forward, and amongst them was a key witness, another Border Patrol agent, Francisco Lara, who made a shocking revelation.
I look south and I see the silhouette of the young woman. So I completely forget about Mr. Burgos and I start running towards the victim.
See the victim?
As soon as I see the victim, I approach and I start yelling. Like, señora, despierta, estás despierta. Ma'am, wake up. Because at this time, all I see is blood. I told my trainee, I call him Schmitty. I like, Schmitty, is that what I think I'm looking at? And I see the silhouette and I immediately start running towards her. And that's when I tell him, like, I start yelling at her, estás despierta, are you awake? Do you have any gloves? He's like, no, I do not. So I say, I don't have any gloves. And I asked my trainee, Schmitty, do you have any gloves? And thankfully, being the great agent that he was, he did have a pair of gloves.
Burgos had devised a strategy, as moments after his ex-wife and son, he ended up calling the cops, claiming that a murder had been committed. Officer Lara explains how he tried to con everyone.
And I immediately check for a pulse. I don't feel a pulse. I look at my fingers and they're covered in blood, because I checked her neck area. So I don't feel a pulse. So I immediately see her left wrist. It's facing up. I check her wrist, and again, I do not feel a pulse. Right away, I tell Mr. Burgos, sir, I think she's 10-7, which means that she's dead. And he's like, yeah, it looks that way. So I'm radioing everything into our station, and I'm letting him know what I'm seeing. At this time, he's standing there. Not really, the supervisor normally takes control of the situation and radios in everything to the station. Once again, he's quiet. I'm the one relaying everything that I'm seeing to the station. I'm processing everything in, I'm taking it in, and I'm telling them what I'm seeing. And right away, I start telling the camera operator to start scanning the river. I tell him, scan the river, see if you see anybody going back.
Burgos had used his police training, carry out the crime in a bushy area, where Griselda ended up having 27 stabs, and baby Dominic had received 2 as well.
Next to the victim, I check her. Mr. Burgos is standing over here too, I guess on the other side of her. So I tell him she's 10-7, which means she's dead. Radio everything in. I told base 2, I think she's dead. They tell me, take a step back, treat her as a crime scene. So before anything, I told my trainee, go to the gate and open it for the paramedics. He takes off. So before I take a step back, I'm surprised to see so much blood. So I grab my head and I'm like, where is all this blood coming from? I take a step back. At the time he picks her up, I could see the shadow of her face.
Officer Lara, a junior at the crime scene, could not believe his eyes as he watched his senior, Officer Burgos, handle the victim with shocking indifference and remained completely unfazed by the brutality of his action.
I get a phone call from my team leader. My team leader tells me, hey, we already activated the Border Patrol unions, the lawyers for you. Before you make any statements, we already got lawyers. And I'm like, we already made our official statement. He was surprised. He's like, "Oh, you did?" I'm like, "Yes." He's like, before he hangs up, he's like, "Just so you know, there's a rumor saying that the dead woman is Burgos' side chick." I'm like, "All right, 10-4, let me call you back."
It wasn't until detectives began investigating the murder that Officer Lara realized that the woman was Burgos' ex-girlfriend and the mother of his child. This revelation left him in a deeply emotional and shocked state.
We just heard her.
Going to question answer basis, Mr.
I'm good, sir. Thank you, Your Honor.
That is exactly how everyone in the court felt, and we can only imagine the condition of Griselda's family. It turned out Burgos had committed this horrible act just because he was refusing to pay child support. Finally, after listening to hours of testimonies and getting evidence, the jury reached a verdict.
In cause number 2018 CRA 852D1, in the case of the state of Texas versus Ronald Anthony Burgos Aviles, the jury has returned a unanimous verdict. I'm about to read the verdict of this jury on punishment as to count number 1. Special issue number 1 on count 1. Whether there is a probability that the defendant, Ronald Anthony Burgos Aviles, would commit criminal acts of violence that would constitute a continuing threat to society. Answer, yes. Signed by the foreperson. Whether taking into consideration all the evidence, including the circumstances of the offense, the defendant's character and background, and the personal moral culpability of the defendant, there is a sufficient mitigating circumstance or circumstances to warrant that a sentence of life imprisonment without parole rather than a death sentence be imposed. Answer, yes. Signed by the foreperson of the jury.
The jury unanimously decided that Burgos would receive life imprisonment instead of the death penalty. Now, many might argue that the death sentence would have been a more fitting punishment for such a heinous crime.
You heard me announce the verdict of the jury with regard to both counts of this indictment. It is now my job to sentence you in accordance with that indictment, with that verdict. Do you understand that?
Yes, sir.
After being found guilty by this jury of 2 counts of capital murder, and after giving us the verdict that they have just announced, it is my job now to pronounce sentence. As to count 1 of capital murder, and as a result of the sentence of the verdict of the jury, you will be sentenced on count 1 as to capital murder to a term of life without the possibility of parole. As to count 2,
Burgos was immediately transferred to the jail and is guaranteed to die there. The shocking encounter truly left everyone speechless, and it is even more saddening that it took 5 years for justice to be delivered to the poor victim's family. Well, nothing might top the brutality shown by this officer, but this next tyrant made another huge mistake.
Nothing in his hands, and he was shot twice
In 2011, during a routine traffic stop, Officer Osvaldo Villarreal fatally shot an unarmed Benny Herrera. The victim's family filed a lawsuit, but it took 5 years for the case to reach pretrial, as Villarreal's attorney attempted to argue for qualified immunity.
It's a tragic case, there's no question about that. But Officer Villarreal was required to make a split-second life and death decision.
What required him to do that? It doesn't look to me as though he was the initiator.
The fact that Mr. Herrera, first of all, he had been acting erratically before the shots were fired, moved from a place of relative safety on the shoulder of the road into the roadway. He was skipping
But if we're
backwards.
talking about Officer Villarreal, how much did he know about the prior behavior?
He saw all of that.
I have to say what you're saying is inconsistent with what I saw on his own camera. That is to say, the point at which he began to get close enough to see anything. Some of that earlier stuff was on the other camera, but not on his.
Officer Villarreal had shot the poor suspect only a second after he asked him to take his hands out of his pocket, and sadly, the attorney was defending this monster.
All at one point, his camera was was turned on, but
His
he
camera was,
testified.
his camera was turned on well before he got to the scene.
He testified in deposition that he saw Mr. Herrera on the side of the road, and then he saw.
Well, he can testify to what he wants to testify to, but I want to tell you what I saw on his own camera tells me that the early part of this he did not see, could not see. That was his intention, you say?
That was his intention, and that's in his deposition.
Again, I'm relying on what's on the videotape, and now this is in Officer Villarreal's car. I hear him say, "Take your hand out of your pocket," and I hear the gunshot almost simultaneously.
Exactly.
They cannot be separated by more than a second.
And that's exactly the time period when Officer Villarreal had to make his decision.
Shockingly, even the police department cleared Officer Villarreal's conduct, but the judge had another idea.
Here, Mr. Herrera was arguably complying with Officer Villarreal's order to remove his hand from his pocket at the time that he was shot. So how is it that we determine that we should grant qualified immunity?
Because qualified immunity allows for police officers to make mistakes. It allows for the possibility that officers will make mistakes in judgment, and that's exactly what happened here. Officer Villarreal had a choice to make. Do I wait and see whether there's something in the hand that could kill me, or do I shoot? And he made the decision to fire. We know with the benefit of hindsight, obviously, that was wrong.
Is it safe?
The officer was about to face the consequences of his actions as the judge unanimously decided that his qualified immunity should be tossed.
As long as the historic facts are undisputed, the question of whether or not Officer Villarreal's actions were reasonable is a question of law. It's not a question that you give to a jury, because we don't want juries second-guessing the very, very difficult life and death decisions that officers have to make.
I agree, but at this stage, again, this is not an argument to a jury. For us to even have jurisdiction over this case, we take those facts. You're saying that as a matter of law, Officer the shooting here was legal.
Yes,
Those
it was objectively reasonable. Well, not just those facts. Officer Villarreal knew that Mr. Herrera was a suspect in a domestic violence incident. Okay. He knew that he had gang affiliation, that he was on parole, that he had a warrant out for his arrest. All of those things factor into
on parole. I don't remember on parole. They said
on parole, yes, and there was a warrant out for his arrest.
What do we know about what Officer Villarreal knew with respect to whether he was armed?
We know that dispatch told Officer Villarreal and Officer Miali that Mr. Herrera was not known to be armed.
The attorney continued to make bizarre and illogical arguments, but the judges swiftly rejected them, firmly believing that the officer should at least stand trial for his actions.
no, so the suspect had refused to put up his hands, had threatened the officers, and an officer believed that she saw something in the suspect's hand, saw him move his arm, and was worried he was going to shoot her. But yet we affirmed the denial of qualified immunity in part because the suspect had not brandished a weapon or spoken of a weapon.
I do recall that case, Your Honor.
The domestic violence incident was over.
Yes, and there.
So, I mean, how does that strengthen your case? I mean, that was, if you're arguing that it was an ongoing domestic violence, so.
It wasn't an ongoing domestic violence incident, but he was warrant out for his arrest, that he had known gang affiliations, and all of those things factor into, am I afraid of this encounter, or do I think that this is going to be a perfectly safe encounter? And everything that they observed, or a lot of the things that they observed, heightened the situation to a point where it was objectively reasonable for the officers. Nobody disputes that, for example, that it wasn't objectively reasonable for the officers to have their guns out. They were going to do a felony stop. Domestic violence under California law is a felony. So they had their guns out. There's some question about whether or not there were other alternatives available. Well, in the split second that decision had to be made, you couldn't put the gun down and pick up a baton. You couldn't put the gun down and pick up a taser, assuming that Officer Villarreal even had a taser. I think there's testimony in the record that he didn't have a taser available to him. He had to make a decision based solely on what he knew at the time. And it's easy for us to sit in hindsight and say, well, Mr. Herrera didn't have a gun. Mr. Herrera didn't really pose any
I don't think
threat.
anyone here said that one time.
No,
I think what we're focusing on, again, the narrow standard we have to deal with here. And That's what we're dealing with. This is not a jury trial. This is not summary judgment. It's a very limited thing. No one here is raised about the fact he didn't have a gun.
I understand. The trial court did.
The plaintiff's attorney stepped forward and presented compelling arguments that further solidified the need for the officer to face trial, strengthening the case against him.
And that the officers perceived a heavy object in that pocket. That's...
First part, yes. Second part, a little less clear. But I think there's no question that he had his hand in his pocket.
Well, and both officers said it looked like he had something heavy in his pocket.
Okay.
All right. And then just before Mr. Vial opened fire, Mr. Herrera rapidly removed his hand and moved quickly, it seemed like, toward the officer's car. Why isn't that enough?
Well, because sticking on the undisputed facts, the officers had no information that any weapon was involved in a crime. They were specifically told he was not known to carry weapons. He had nothing in his hands, and he was shot twice and killed. We specifically asked the officers about their training, and they conceded, which is included in the cites in our brief, that deadly force is a last resort, only to be used in the direst of circumstances, only when no other reasonable measures are available. And
finally, the judges reached a conclusion and gave one last shut-up call to the defense attorney.
If everything goes bad for your client, that is to say, if we send it back, if the jury says no qualified immunity, and if the jury comes in with an award of some amount of damages, will your client pay those damages out of his own pocket, or will it be paid by his employer?
It should be 99.9% of the times it's paid by the employer. I don't see why it would be different.
Well, by statute, California statute says it's paid by the employer unless they're punitives.
Yes,
isn't that right?
That was what I was going to say.
So that doesn't say 99%, it says 100.
Well, I was going to say, unless there were, if there were punitive damages, the city would have the option of deciding whether to pay those punitives.
The judges decided to toss Officer Villarreal's qualified immunity, and the case was set for trial. He was immediately fired from the police department, and the city also agreed to pay $1.4 million to the victim's family. As for Villarreal, justice demands that he face the consequences for the brutal killing of an innocent individual. Well, that brings us to the end of this video. Today we witnessed justice served as corrupt cops face the consequences of their heinous actions in Courtroom. These officers who betrayed their oath by committing unthinkable crimes against innocent people were rightfully held accountable and received the sentences they deserved. If you agree, please support us by liking this video, and also if you enjoyed this video, watch the moments where these corrupt cops were caught in the act.
Please. Huh? I'm not turning my camera off. Okay.